Welcome in. If you are trying to make sense of the digital landscape right now, or if you're simply curious about where technology is dragging the creative world next, you are absolutely in the right place.
You really are. It's wild out there right now.
It is. And we have tailored today's deep dive specifically for you. We are stepping into a very specific, incredibly high-stakes battlefield today. We are exploring the collision between Hollywood, which is obviously an industry historically built entirely on human creativity, and the explosive new world of generative AI companies.
And it is a critical intersection to examine. I mean, you have a century-old industry fiercely guarding its intellectual property, suddenly face-to-face with a technology that, by its very nature, fundamentally requires the ingestion of vast amounts of data just to function.
Right. To exist at all.
Exactly.
So to guide this exploration, we're drawing from a really fascinating legal analysis published in the Daily Journal on February 20, 2026. This source maps out what is happening far away from the public eye. Okay, let's unpack this. The core thesis we are looking at is that the Wild West era of artificial intelligence is coming to an end.
But not how people might expect.
No, exactly. That ending isn't arriving through dramatic cinematic courtroom verdicts. Instead, the boundaries are being drawn through high-stakes, closed-door mediations and these groundbreaking confidential settlements.
Which establishes a crucial context for you as the listener. These disputes are not minor corporate squabbles over server space or mere celebrity grievances. What we are witnessing in these private mediation rooms is the establishment of the licensing frameworks and the foundational rules that will govern how creativity, media, and technology interact for the foreseeable future.
It's the blueprint for the next 20 years.
Absolutely.
Let's start with a massive piece of that emerging framework, the $1.5 billion settlement involving the AI company Anthropic and their large language model, Claude.
The numbers on this one are just staggering.
They really are. The scale of the initial lawsuit it's hard to wrap your head around. 300,000 authors sued Anthropic, claiming the company copied their books by the millions to train Claude.
Millions of copyrighted books.
Yes, and then allowed users to generate outputs that were substantially similar to that original work.
The legal threat to an AI company in that specific scenario is existential. It's a nightmare. The case landed in the Northern District of California before senior U.S. District Judge William Alsup.
Right.
And when he evaluated the facts, he noted that while generative AI certainly holds promise, the concept of fair use does not offer a blanket shield, especially in instances where the training data included pirated books.
Which was a major claim there.
Right. And based on that, he certified the class action.
Walk me through that. Why is class action certification such a terrifying trigger for a tech corporation? What actually changes the moment a judge makes that ruling?
It changes the fundamental math of the company's survival. Instead of fighting a few isolated authors, Anthropic suddenly faced a unified front of 300,000 plaintiffs. Under copyright law, if a jury finds willful infringement, statutory damages can be awarded per infringed work.
Oh, wow.
Yeah. When you multiply those damages by hundreds of thousands of books, the potential penalty skyrockets into the high hundreds of millions or even billions of dollars. The source we're looking at explicitly refers to this as a company-killing threat.
So, facing the possibility of complete financial ruin, Anthropic pivots. They bring in mediator Lane Phillips and secure a $1.5 billion settlement, which is huge. It is cited as the largest settlement in copyright history. But the detail that really stands out the most to me is that this historic payout only covers past infringement.
And that distinction is paramount. By limiting the settlement to past actions, Anthropic essentially bought its way out of an immediate localized disaster.
But it didn't solve the problem.
No, it didn't solve the underlying legal ambiguity for the future. What it does is clear the ledger. It allows the authors and the tech company the breathing room to negotiate a forward-looking licensing market completely from scratch without the threat of a billion-dollar trial hanging over the conversation.
That makes sense. Now, if Anthropic felt cornered enough to pay out $1.5 billion, you might assume the legal precedent is firmly on the side of the creators.
You would think so.
Here's where it gets really interesting. That assumption falls apart when we look at the Sarah Silverman case, Cadre v. Meta, regarding Meta's Llama AI model.
A very similar setup.
Almost identical. The plaintiffs allege the exact same thing, that Meta trained its model on datasets of copied books. It is happening in the exact same courthouse. But it was assigned to a different judge, U.S. District Judge Vince Chhabria.
What's fascinating here is how the human element within the legal system completely upends expectations. Judge Chhabria reviewed very similar facts, but applied a much more skeptical lens to the plaintiff's specific theories of harm.
He wasn't buying it.
Not initially, no. He required the authors to demonstrate that the AI's outputs were substantially similar to their specific individual books.
Which is incredibly hard to do.
It's a very high bar when dealing with a model that blends millions of sources together. Consequently, he dismissed the key claims based on the record before him.
That feels like a complete courtroom coin toss.
Right.
You have two judges in the same building looking at the same technology and reaching drastically different conclusions on how copyright law actually applies.
And that extreme unpredictability is precisely why mediation is rapidly becoming the gold standard for resolving generative AI disputes.
It's too risky otherwise.
Way too risky. The intellectual property concepts at play are dense and highly technical. They challenge judges and juries who may not possess deep software engineering backgrounds.
Right.
So for massive tech companies and powerful Hollywood studios, taking these cases to trial is viewed as an unacceptable gamble. A single adverse ruling doesn't just result in a financial penalty. It sets a binding legal precedent that could permanently dismantle an entire business model.
No one wants to risk the survival of their industry on a roll of the dice.
Exactly.
But the legal system isn't the only arena where these battles are being fought. Sometimes, public opinion steps in as judge and jury long before a lawsuit is even drafted. The Scarlett Johansson situation with OpenAI is a prime example of this, and honestly, it feels like life imitating art.
Oh, you are referring to OpenAI founder Sam Altman's well-documented affinity for the 2013 film Her.
Yes, where Johansson voices an artificial intelligence.
Right.
Altman actually courted Johansson to become the official voice of ChatGPT. She declined the offer. But on the eve of their major product launch, OpenAI released a synthetic voice that sounded uncannily similar to hers anyway.
The reaction from Johansson and her legal team was immediate.
It was fierce.
She issued cease and desist letters demanding that OpenAI disclose the precise development process and the underlying training data used to create that specific synthetic voice.
And OpenAI folded almost instantly. They shelved the voice and issued a rather vague statement about their voice selection process. They didn't even attempt to fight it out in court.
They avoided the fight because the alternative was legal discovery. If that dispute escalated into formal litigation, OpenAI would be legally compelled to hand over internal communications, developer notes, and the specific data sets used to train that voice model.
Their secret sauce.
Exactly.
Yeah.
For a company whose competitive advantage relies on the absolute secrecy of its algorithms, opening that black box in a public court record is a nightmare scenario.
So the threat of reputational harm, combined with the threat of discovery, forced their hand.
Yes.
We saw a very similar dynamic with OpenAI's launch of their video generator, Sora 2.
That was a mess.
It really was. The initial policy they established for Sora 2 was incredibly skewed. Under their default rules, users were freely permitted to generate videos using copyrighted characters, like famous cartoon mice or superheroes, unless the right shoulder proactively opted out.
But it was different for people, right?
Exactly. Generating the likeness of a real human being required an explicit opt-in.
That policy structure placed an immense burden directly on the creators and the studios. It effectively meant the intellectual property owners had to continuously police the platform.
Just constantly searching for their own stuff.
Constantly searching for unauthorized generations of their work just to issue takedown notices, while the AI platform profited from the traffic.
Well, the pushback from the creative community was a tidal wave. It took only 72 hours for OpenAI to completely reverse course and implement an opt-in model for copyrighted content as well.
That was fast.
But the critical context here is that while they were weathering this controversy, Sora 2 still hit #1 on the App Store.
Which highlights a fundamental dynamic you should keep in mind as we watch this industry evolve. The financial incentives for these generative AI platforms are astronomical, and consumer demand is just insatiable.
People want the tools.
They do. And because of that, AI companies will continuously push the boundaries, deploying aggressive policies to see what the market will tolerate. They will only course correct when public outrage or severe legal threats make their current path unsustainable.
They will push the line until someone forces them to draw it.
Precisely.
And it isn't just A-list actors or massive studios having to force that line. Let's look at a pivotal case from August 2024 involving everyday creators Vacker v. 11 Labs.
This is a really important one.
This lawsuit was brought by two non-celebrity voice actors who make their living narrating audiobooks.
Yeah.
They sued 11 Labs, alleging the company ingested their narrated audio files to create artificial voices named Adam and Bella.
This case is widely recognized as the first major generative AI dispute to reach a settlement. And the legal mechanism the plaintiffs used is highly technical.
Right, they didn't just claim standard copyright infringement.
No, they filed claims under the Digital Millennium Copyright Act, or DMCA. Their specific allegation was that 11 Labs deliberately stripped the digitally embedded copyright management information, the CMI, from the audio files before copying them.
Okay, to put that in physical terms, it sounds akin to scratching the serial number off a piece of stolen equipment so it can't be traced back to the owner.
That is an incredibly accurate analogy, and the litigation phase of this dispute was notoriously brutal.
It got nasty.
Very. 11 Labs mounted an aggressive defense. They challenged the plaintiff's standing. They filed motions to transfer the venue to make the logistics harder on the voice actors.
Just bleeding them dry.
Exactly. And they even invoked New York's SLAPP statute against the creators.
Help me understand that last part. A SLAPP statute strategic lawsuit against public participation is generally designed to protect free speech, right?
Usually, yes.
How does a tech company use that against a voice actor suing for copyright infringement?
It is a highly controversial legal tactic. 11 Labs essentially argued that their development of AI technology constituted a matter of public interest and free speech.
Wow.
Yeah. By invoking the SLAPP statute, they were able to threaten the individual voice actors with the prospect of paying the tech companies exorbitant attorney's fees if the lawsuit failed.
That's intimidating.
It is designed to create a chilling effect, forcing plaintiffs to weigh their pursuit of justice against the very real risk of personal bankruptcy.
That is a terrifying calculation for an independent contractor.
It really is.
After a year of that kind of intense legal warfare, the two sides entered mediation with Jeff Kikachavan. They reached a confidential settlement in August 2025, with both parties choosing finality over the immense financial drain of ongoing litigation.
It just demonstrates how grueling these technical copyright battles can be.
Yeah.
But contrasts that protracted struggle with the legal strategy executed by Tony Robbins against InnoLeap AI and Mira Muse.
Oh, this one is brilliant.
It represents a completely different approach to protecting a persona.
The Robbins case is fascinating. These AI companies launched platforms like YesChat.ai, marketing a quote-unquote Tony Robbins GPT.
Right.
They ingested his proprietary content, recreated his digital likeness, and charged subscribers for access to a chatbot dispensing advice in his signature style. This unauthorized bot was actually competing directly with an official AI clone that Robbins was offering on his own website.
Given those circumstances, the standard expectation would be a massive copyright infringement lawsuit regarding the unauthorized ingestion of his books and seminars.
Sure, attack the training data.
But his legal team executed a tactical bypass. They entirely sidestepped the murky, unresolved debate surrounding AI training data and fair use.
They didn't even go there.
Nope. Instead, they grounded their lawsuit in established California celebrity trademark and misappropriation laws.
They relied on the right of publicity.
Precisely. California law robustly protects an individual's right to control the commercial exploitation of their name, image, and likeness. By framing the lawsuit as a straightforward misappropriation of his brand for commercial gain, Robbins' team neutralized the complex, novel technological defenses the AI companies might have deployed in a copyright dispute.
They kept it simple.
Extremely simple. They weren't debating how the algorithm functioned. They were simply pointing out that his face and name were being used to sell a product without permission.
And the resolution was remarkably swift. By July 2025, the AI companies entered into a stipulated judgment. They agreed to a permanent cease and desist, committed to destroying all copies of the unauthorized models, and paid Robbins a $1 million settlement.
It signals a potent alternative strategy for high-profile figures, bypass the algorithm entirely, and attack the commercial branding.
It is a highly effective use of existing statutes to manage emerging technology. But while individual figures are navigating these alternative routes, the massive corporate entities, the legacy studios and record labels, are engaging in a much broader, systemic reshaping of the landscape.
The heavy hitters.
Let's shift to those massive entities. In June 2025, Disney, NBC Universal, and Warner Bros. Filed a monumental lawsuit against the image generator Midjourney.
That's a big one.
Massive. The core allegation is that Midjourney utilized their heavily protected intellectual property to train its models, enabling users to generate highly accurate images of characters like Buzz Lightyear and Darth Vader. Midjourney is mounting a complex defense, but there is a ticking clock here. A highly anticipated mediation completion deadline set for August 2026.
If we connect this to the bigger picture, we have to look at the parallel moves these studios are making. In December 2025, Disney and OpenAI announced a precedent-setting licensing partnership.
Right.
That agreement is undoubtedly casting a long shadow over the upcoming Midjourney mediation.
How does a partnership like that actually function in practice? Is Disney just handing over their vault to OpenAI?
Far from it. It is a highly controlled ecosystem. Disney is demonstrating a willingness to integrate their legacy IP with generative AI, but strictly under their economic framework and with their explicit blessing.
So they hold the keys.
Completely. The AI model is trained on authorized data, the outputs are likely subject to strict brand safety guardrails, and crucially, there is a structured revenue sharing mechanism in place. It establishes a template for how a legacy studio can monetize AI rather than just fighting it endlessly in court.
Right. It's like saying, we aren't inherently opposed to the technology. We're opposed to you profiting from our property without cutting us in.
Exactly.
That sentiment seems to be the exact wedge currently fracturing the music industry. Let's look at the timeline there. In June 2024, Sony Music, Universal Music Group, UMG, and Warner Records formed a united front.
The big three.
The Big Three. They launched a massive coordinated lawsuit against the AI music generators Udio and Suno, alleging unauthorized copying of their catalogs to train models capable of mimicking famous recording artists.
The initial strategy was completely unified, but the long-term tactics rapidly diverged. By October 2025, UMG executed a major strategic pivot. They settled their litigation with Udio and announced the formation of a licensing partnership. This partnership essentially created a walled garden.
Let's define that walled garden for the listener. What does that actually mean for the average user or artist?
It means the AI platform transitions from an open, unregulated sandbox into a closed, licensed environment. Users can still generate music, but the AI is strictly trained on and interacting with legally licensed music.
Got it.
Furthermore, the outputs are subject to usage constraints, and UMG implemented a system where artists receive compensation tied both to the training process and the subsequent generation of outputs utilizing their distinct vocal or instrumental styles.
So they found a way to track and pay for the AI's inspiration, basically.
That's the goal.
Warner Records followed suit shortly after, reaching a similar settlement and licensing arrangement with Suno. They seemingly accepted that generative music technology isn't going away, so they decided to capture and control the economic value of that technology.
But Sony Music has taken a starkly different path.
Yeah, Sony remains the lone holdout. They have steadfastly maintained their litigation against both Udio and Suno, refusing to sign these early licensing treaties.
That's a bold move.
Why hold out when your two biggest competitors are already building their walled gardens and securing new revenue streams?
It comes down to long-term leverage. Sony may calculate that by securing a definitive, punishing court ruling against an AI company, they establish a permanent legal precedent.
Playing the long game.
Exactly. That precedent would give them immense negotiating power, not just over Udio and Suno, but over every future generative AI company that ever enters the market. They are enduring the short-term cost of litigation to potentially dictate the terms of the entire industry later.
So what does this all mean for you, the listener? We have traversed a landscape spanning synthesized celebrity voices, audiobook narrators fighting for their livelihoods, and legacy studios restructuring their massive IP vaults. The central takeaway is that the tech industry's foundational ethos of move fast and break things is effectively over in the realm of generative AI.
It's done.
We are actively transitioning into an era defined by complex licensing deals, cross-licensing frameworks, and highly structured compensation models. The wild frontier is being fenced in.
And the nature of that transition is why this matters to you directly. Whether you are an independent creator trying to protect your work, a professional utilizing these tools to streamline your workflow, or simply a consumer navigating an increasingly synthetic media environment, you are operating within a system whose rules are being finalized right now.
Right now as we speak.
Yes. The guardrails of the internet's future are not being debated publicly by elected lawmakers. They're being drawn by corporate attorneys and private mediators in closed-door settlements.
It is a profound shift in how our cultural infrastructure is built.
It is. And this raises an important question, something outside the scope of the lawsuits themselves, but vital to consider regarding our future. We are seeing massive legacy studios like Disney, UMG, and Warner secure these exclusive walled garden licensing deals because they have the capital and the century-old IP vaults to negotiate them.
They have the leverage.
Right. But if the future of generative AI relies entirely on training data locked inside these corporate walled gardens, what happens to new independent human creators? Are we inadvertently engineering a cultural future where the only media produced is just an AI-generated remix of 20th century franchises, permanently locking genuine new human innovation out of the market?
Wow, that is a fascinating and honestly unsettling prospect. Are we building a machine that only knows how to look backward, controlled entirely by the companies that own the past? That is a heavy, essential thought to leave you with today. Thank you for joining us on this deep dive into the hidden licensing wars shaping our digital reality. We hope this armed you with the context you need to navigate the changes ahead. Keep questioning the tools you use, keep exploring, and we will catch you on the next deep dive.